On the telephone ending in 1336. Tell us your name, please.
Dominic Hall.
I come in sui juris.
Only one of you actually has that phone number, and the other people are just wrong about what their phone number is. Who's calling ending in 1336?
Sui juris and personal persona. I'm Stephen Tyrell White, beneficiary and sovereign. I'm here under fraud, menace, and duress. Fiduciary Daniel Williams Norbeck.
Okay, Mr. White, we're going to pop you over in the waiting room because you're just going to be a distraction for all the citizens here willing to abide by the laws of our country. So we'll pop you over in the waiting room and we'll get back to you. In case you guys have ever heard of the term sovereign citizen in the news, that's what one of them sounds like when they try to come to.
Welcome to today's breakdown, where the legal system collides with the bizarre world of sovereign citizens and courtroom Karens. Today's lineup has it all: wild objections, legal gibberish, defiant defendants, and judges who don't have the patience for nonsense. We'll start in Judge Norbeck's courtroom, where he spots a sovereign citizen right out of the gate and decides to give everyone a mini crash course on what they sound like. But don't get too comfortable, because what begins as simple arraignment spirals into jurisdictional arguments, pseudo-legal jargon, and some of the boldest courtroom defiance you'll see. We've also got a defendant who insists she can out-lawyer actual lawyers, a judge trying desperately to keep things on track, and yes, someone actually attempts to dismiss a criminal charge at arraignment. Stay tuned, because the deeper we go, the stranger it gets. Now, let's jump right into the chaos.
Mr. White, are you able to hear me?
Your Honor.
All right. I'm going to read this to you so you understand what you're charged with. This says that on January 7th of this year, on 2nd Street there in the city of Fenville, that you were driving while license suspended. That is a misdemeanor. It's punishable by up to 93 days in jail and or $500 fines and costs. Do you understand your charge?
Objection, Your Honor. I do not. I do not understand my charges or
okay. I'm going to mark you down as not guilty, and we'll set you for a jury trial. You can continue to.
Your Honor. Your Honor. You practice in front of bench. You practice in front of bench. That's my job or my attorney job. I'm sui juris. I'm pro pria.
Okay, Mr. White. I don't know where you read the stuff that you're saying, but it's legal nonsense. It means nothing in a court of law. So if you're not willing to state that you even understand or recognize the authority of the court, my options are I can make you come in for arraignment and not give you a PR bond, and then you'll have to post bond to not sit in jail. You want to do it that way instead? Right now, if I get through arraignment with you, I'll give you a PR bond. Mr. White?
I don't listen. I'm asking you a question.
What's the question, sir?
I'm not arguing with you, Your Honor. I just want you to hear me.
Okay, but I don't want to listen for 20 minutes. Go ahead and ask your one question, and we'll start there and see if it's a real question.
Am I on the record?
Yes.
It's not going to take 20 minutes, Your Honor. I give you my word.
Well, you said you have a question, sir. What's the question you want to ask?
Is this criminal or is it civil?
This is criminal, sir. It's punishable by up to 93 days in jail and or $500 fines and costs.
Hey, if it's criminal, can I ask to dismiss?
And there it is, the classic sovereign citizen starter pack. Deny understanding, reject authority, and throw in some pseudo-legal word salad like sui juris and beneficiary. Judges have heard it all before, and you can see Norbeck's patience wearing thin immediately. Here's the thing, arraignment isn't about winning your case, it's just about being told what you're charged with and entering a plea. But sovereigns treat it like open mic night for conspiracy theories. The judge lays it out clearly. Either we get through this today on Zoom with a free PR bond, or you come in person and pay $300 cash. That's not just patience. That's the judge giving the defendant a golden ticket out of bigger trouble. But does he take it? Of course not.
It's because this is just arraignment, sir. What you're talking about is trial. That would be several steps down the road. Arraignment is just for you to make sure that you understand what you're accused of, what the penalty is, and for you to enter a plea. You're accused of driving while license suspended. I read to you what the possible penalties are, and I asked you if you wish to plead guilty or not guilty at this time.
No, Your Honor, I'm a beneficiary and I'm a sovereign. I'm here under fraud, menace,
sir. Those sentences don't mean anything. They have no legal meaning whatsoever.
It's guaranteed by
so
my constitutional.
I've indicated that since you can't understand arraignment, I've entered a plea of not guilty on your behalf. I've set you for a jury trial. You can represent yourself free of charge, or you could hire an attorney. And now you must make a choice, sir, for bond. If we get through the arraignment with you on Zoom, I'm going to give you a PR bond, personal recognizance bond. That means you don't have to post any money. We're essentially trusting you that you'll keep coming back for your court dates. It is no driving without a valid driver's license. If you cannot get that far, in other words, if you really don't understand what's happening here, then I'm not going to allow you to be arraigned by Zoom. I'm going to set you for arraignment in person. And you will come to this courthouse. You will not get a PR bond. You will get a $300 cash or surety bond, meaning that you will need to post $300 in cash, or you will sit in jail from that day until your trial date. So I'll give you a choice. Do you want to be arraigned over Zoom like we're doing today, or would you like to come in and be arraigned in person?
Well, I object to all of this, Your Honor, because at this point, I don't even understand the charges. I do not understand the charges. I'm not trying to.
That's fine. No, sir, you're allowed to. Sir, you're allowed to object, and I understand your sentence that you don't understand the charges. And so I will attempt to work with you for that for a second. I'm going to read the charges to you, okay? This says that it takes place on January 7th of this year. You understand that, right? The date that I just read.
I'm saying I do not. At this point, Your Honor, it's I was saying this. It was a jurisdiction matter. It's a jurisdiction matter. That's the problem
with you arguing jurisdiction. I am a lawyer, so I understand what jurisdiction means. I'm not sure you do. The accusation is that you're driving around on 2nd Street in the city of Fenville, meaning in Allegan County, and that you're doing so when your driving privileges with Secretary of State have been suspended or revoked. Because this is the county. Yes?
Objection, Your Honor. I travel. I don't drive.
Okay.
I have no contact.
Sir, here's what we're doing, Mr. White. You are no longer able to be arraigned by Zoom. What I'm going to do is adjourn this. I'm going to adjourn this, and you will get notice at your address there. You will come in, and we will arraign you in person. I'm telling you that I'm not going to give you a personal recognizance bond, sir.
It has to be. Before we can proceed,
White,
before you can proceed, it has to be addressed, Your Honor.
Because we are on the record, I'm going to make this infinitely clear. You're going to get notice to appear in front of me. You have two choices. If you do not appear, I'm going to put out a bench warrant for your arrest. If you do appear, we will have this conversation again about arraigning you to see if you understand the charges, but you are not getting a PR bond. You will need to bring with you $300 cash or surety, or you will be in jail. Do you understand those two options, A and B?
That's a violation of my constitution.
This is the sovereign citizen equivalent of trying to play chess by shouting checkmate on the first move. The defendant hears the word criminal and immediately leaps to, well then, dismiss the charges. Except that's not how the law works. Arraignment is literally the first procedural step, not the final boss battle. It's like trying to cancel a marathon at mile 1 because your shoes are untied. Judges almost never dismiss at this stage unless the charges are blatantly invalid, which this isn't. But sovereigns live in a world where magical words can supposedly reset the board. Spoiler alert, they can't.
So we're all set for today. We're done talking. We cannot make any progress. You will be asked to come in person for arraignment. You can either choose to come in for arraignment, or you can choose to not be here. If you choose to not be here, a warrant will be entered for your arrest. And if you do choose to be here, make sure you bring that $300 because you're not getting a personal recognizance bond. But we are done with this hearing. I'm going to go ahead and release you. Thank you.
When's my date?
Following case 2400390201. The people of the state of Michigan versus Tanea Nicole Tubbs. This matter is scheduled today for competency hearing. Appearances for the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
William Glenn, P 36794 on behalf of Ms. Tubbs. Ma'am, state your name.
Beneficiary, Tanea Nicole Tubbs.
All right, Ms. Tubbs, you have a constitutional right to be physically present in the courtroom. Do you agree to waive that right and hold this hearing by Zoom?
I agree.
Okay, thank you. Counsel, I've received a report dated February 13th, 2025, authored by Andrew P. Sheff, licensed psychologist, consulting forensic examiner. Have you both had an opportunity to review that document?
Yes,
Yeah. Yes, Your Honor.
Do you both agree, stipulate to that being admitted as court's exhibit number 1?
Yes, Your Honor.
And that'll be marked and admitted as court's exhibit number 1. All right, and do you stipulate to its findings?
Yes, Sean.
Yes, Your Honor.
All right, then the court will find that it says opinion. It's my opinion that Ms. Tubbs is competent to stand trial.
Yes, Sean.
Okay, then it says, at the last paragraph says, while I recognize the ultimate decision in this matter rests upon a judicial determination, it's my opinion that Ms. Tubbs was competent to stand trial at the time of this evaluation. You both stipulate to both of those findings?
Yes, Sean.
Yes, Your Honor.
Right, then the court will sign an order. Is she receiving medication? Is she?
She's in the Calhoun County Jail. I don't know yet.
Ms. Tubbs, are you receiving medication?
No, Your Honor.
No medication? All right.
No matter.
And counsel, are either you aware that she's receiving medication?
I am not aware, Your Honor.
I am not aware, Your Honor.
I don't see any mention of medication here, so. All right, and I'm signing the order finding her competent to stand trial. And do we have a trial date on this matter?
March 17th.
What date?
March 17th.
Okay, so this matter is scheduled for March 17th at 9 o'clock. Has counsel had a chance to discuss whether this matter is going to be resolved or not?
Your Honor, I had filed a notice of insanity to get a criminal responsibility report. I have not received that yet. Once I get that, I'll have a good idea as to whether we're going to be able to settle this or whether or not we have to go to trial.
Your Honor, I object on that. I would like to exercise my Sixth Amendment right, and I would like to reserve my rights to not be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, willingly, voluntarily, or intentionally. And I furthermore do not accept any liability of compelled benefit under any unrevealed contract of the commercial agreement. And that's under code UCC 1-207. And I have the rights to represent myself and waive all counsel knowingly.
Ah, yes, the all-time favorite, jurisdiction. Sovereign citizens throw this word around like it's a get-out-of-jail-free card. The problem? They rarely understand what it means. Jurisdiction isn't some mystical loophole. It's simply whether the court has authority over the person and the crime. You're driving on 2nd Street in that county while your license is suspended. Boom, jurisdiction established. The judge even tries to explain this in plain English, but the defendant isn't listening. He counters with the infamous "I travel, I don't drive" line, a sovereign classic. Judges have heard this argument for decades, and it has failed every single time. Yet here we are, watching the cycle repeat.
That you be allowed to represent yourself? Is that what I'm hearing?
That's correct.
All right. Well, then I'm going to voir dire you with regard to that decision. Would you like an opportunity to speak with your client in the breakout room with regard to this decision, counsel?
Well, she said that a couple of times, but I would ask that the court hold off on that till I get the criminal responsibility. So, once I get that, then if she wants to represent herself, then we can,
Well, ma'am, do you want to do are you saying you're not going to do the criminal responsibility evaluation?
I do not need to do any of that, sir.
I'm sorry,
That's defamation of character. I will not be doing any of that. And I would like to exercise.
You are requesting that you not do a criminal responsibility evaluation. Is that my understanding, ma'am?
That is your understanding. Correct.
Well, yeah, with the MIDC's policy, I don't know if I can continue as her attorney of record. She has to have standby counsel appointed if she's going to represent herself. That's my understanding of the current policy.
All right, and you do standby counsel?
No, yeah.
All right, well, would you like to talk with her before she makes this decision? I'd like to have you speak with her.
Yes, Sean.
So, ma'am, I'm going to have the attorney go into a breakout room with you and just talk to you. This is a very important decision. I'm not saying I'm not going to do it, but I just want you to talk with him and understand some of the risks of doing this. And okay.
Your Honor, I understand all the risks and I do not wish to talk to him. I have not talked to him in 6
This is where legal reality and sovereign fantasy collide head-on. The judge acknowledges, yes, jurisdiction can be questioned, but timing matters. At arraignment, you're not litigating constitutional law. You're being told what you're accused of. It's like trying to argue over the rules of Monopoly while someone is still setting up the board. Judges don't dismiss cases just because you shout jurisdiction louder than everyone else. Unless there's a glaring, obvious issue, like charging someone in the wrong county. It won't even get a second look until later. The fact that this defendant won't accept even that basic reality tells you exactly where this is headed. More conflict, more wasted time, and eventually harsher consequences.
So just so I'm clear, you're refusing to talk with him, is that correct?
Correct. I understand all the consequences and repercussions in this case.
Okay, all right. Then let's, ma'am, we're going to need have you sworn in for you to self-represent yourself, okay? I want to ask you some questions just so you understand. Can you swear her in, please?
Ms. Tubbs, please raise your right hand in front of the camera where we can see it.
I do not swear in, but I wish to tell the truth and nothing but the truth.
All right, then will you affirm?
I'm here to reserve
let's
my
have
right.
you raise your hand and you can affirm, okay?
Do you solemnly swear to?
No, do you solemnly affirm?
Do you solemnly affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth.
Okay, you have to put your right hand up, ma'am, please. Let's do it again.
That's against my religion, sir.
All right, then ma'am, I'm not gonna have you self-represent you until you do this. So if you're not gonna do it, we're gonna continue the attorney with you. All right? So you tell me what you want to do, Ms. Tubbs. Because until I go through these questions with you under oath, we're not signing any, we're not.
But I need to know what oath am I going under, sir? I have the right to know what oath I'm going under because I don't go just under any oath.
All right. Well, let's have her raise her hand again, and you say the affirmation. It's not an oath; it's an affirmation. Raise your right hand, please, ma'am.
Do you affirm?
No. Yeah. Okay.
Do you affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth, and I come in as beneficiary, affirm.
All right. Thank you, ma'am. What's your name?
I am the beneficiary, Tanea Nicole Tubbs.
All right. Do you understand that you have a right to have a lawyer represent you in this case?
Yes, sir.
Do you understand that I will appoint a lawyer to represent you if you cannot afford a lawyer?
I waive that right.
Huh?
I understand what you're saying, but I waive that right.
Okay. Do you want to have a lawyer represent you?
No, sir.
Can you afford a lawyer?
Yes, sir.
Okay. What is the maximum sentence in this matter, Madam Prosecutor?
In this matter, Your Honor, it is
Punishable up to 5 years or a
It's-
fine not.
Ma'am, just wait. Let me speak, okay?
I'm
Madam
sorry.
it would be 7.5 years because the defendant, it's carrying concealed weapon, which is a 5-year maximum penalty, but there is a habitual second offense notice. So that would increase the penalty to 1.5 times the maximum sentence, which would put it at 7.5 years.
And here's where sovereign citizen bingo goes full tilt. UCC codes, beneficiary language, disclaimers of liability. It's all being recited like a magic spell. The sad truth is, none of it means anything in criminal court. Judges and lawyers recognize this immediately as copy-paste sovereign script. What's fascinating is the confidence. These defendants truly believe they've uncovered a hidden legal cheat code. But confidence isn't competence, and repeating gibberish doesn't change the fact that charges exist. Notice how the judge just patiently moves on, ignoring the noise. That's years of courtroom experience, knowing when to argue and when to let nonsense burn itself out.
Maximum possible sentence in this matter is 7.5 years because you are a habitual offender second offense notice. So it's 7.5 years is the maximum sentence. Would you like to talk with a lawyer, with a court-appointed lawyer to decide if you want to represent yourself or not?
No, I would like to represent myself and put in the motion to dismiss.
Okay, so ma'am, first of all, can you give me your education?
I
How
have
far have you gone in school, ma'am?
college.
College, okay. And have you represented yourself before?
Yes.
And why do you wish to how many times have you represented yourself?
Twice.
Okay, and then what were those in criminal matters?
One is, yeah,
And what happened with that case?
I got it dismissed.
Okay. And what was the other case you represented yourself, Ms. Tubbs?
I'm actually doing that now. It's for another criminal case, actually.
And you're representing yourself in that case?
Yes.
And why do you wish to represent yourself in this case?
I wish to represent myself in this case because I have learned all the